Thank you. All right, we're back on the record. Have a seat, counsel. Relative to his objection, the statute in subpart 2 indicates NRS 48125 sub 2 that evidence of a no-low contingency plea or an offer from being admitted both in criminal and civil trials. However, in Taylor v. Thunder, 116 Nevada, 968, 2000, the court indicates in its discussion, here we're not discussing an offer to plead guilty. It seems as though that you're discussing an actual plea of no-low. And Mr. McDonald, are you on your phone?
I was going to look up Thunder. Could you explain that to me, please, Judge?
I just gave you the citation. I'm making the ruling now. I don't want you to be on your phone while we're in court and while you're testifying. So we're not talking about, and Mr. McDonald argues that due to his plea of no-low, that nothing associated with that criminal charge would come in and be admissible in this case. Not the criminal complaint, not his conviction, not anything. I believe Mr. McDonald's argument is too broad. The fact that he pled no-low will not be considered by the court. However, evidence of prior bad acts may be admitted prior to the evidence, provided the evidence is relevant and the prior incident is proven by clear and convincing evidence. Even if the trial court determines that the prior bad act evidence is relevant, the evidence is not admissible if its probative value is substantially outweighed by the danger of its unfair prejudice. The determination of the district court is to be given great deference and will not be reversed absent manifest error. Here they're talking about Petrotelli hearings in the criminal context and about bad act evidence. Here, counsel, you're not trying to show me that Mr. McDonald is a bad guy because of this prior bad act evidence. We haven't had any 404B motions. That's not the case. You're requesting this information relative specific instances that are relevant to the best interest findings of this court. Is that correct, counsel?
Correct,
Mr. McDonald, do you have any...
I do have an objection to that.
Go ahead, or just any response at all, not an objection.
Well, there's a response is under NRS 48.025 there's a establishment of character, and when counsel's trying to establish character defamation or defamation of character, there's a certain things that he needs to follow under NRS 48.055 to means to establish character. So,
Mr. Collinsworth, counsel, you are not, as I stated, trying to bring this criminal act in as evidence of bad character, but evidence of factual situation that happened between these same parties in a different court. Is that correct?
That's correct.
And certainly Thunder allows that the evidence of a no-low plea is admissible in a subsequent civil proceeding consistent with the terms of 48035, which states evidence will not be admissible if its probative value is substantially outweighed by the danger and unfair prejudice of the confusion of the issues or misleading the jury. Here, this is a bench trial, and I'm not concerned about misleading the jury. The court understands the impact of a no-low plea. He's not talking about a plea 25 years ago, no-low to some DUI or something.
Judge, is there a way I could request a trial by jury in family court?
Would you like to request? We're
about
3.5 hours into your evidentiary hearing on your motion to modify. Are you requesting a jury as to this evidentiary hearing as your motion to modify?
In regards to what happened,
You're in the middle of your testimony?
well, I ask you, Judge, if there should be basis for a trial based on if there's circumstances which is within our law that if somebody is in prison or is affected by means of monetary losses of over $50,000, there's case law that says that they should have a right to trial, and this respond to custody, which in some states they are now having trial by jury.
Right, so our Constitution does not provide in divorce actions a right to jury trial. Your divorce and custody hearing was in 2016. This is a post-decree motion to modify. Your request for a jury trial is denied. All right, in addition to that ruling, NRS 48035 says that evidence of another act or crime which is so closely related to an act in controversy or a crime charge that an ordinary witness cannot describe the act in controversy or the crime charge without referring to the act or the crime shall not be excluded. Here, my evidentiary ruling is based on those three things: the language of thunder, NRS 48035, the spirit of that, the spirit of the statute. These are the same parties. This is the same act. They have so much relation to each other. Mr. McDonald is charged with telling me what has changed since 2016, and I think that the court really specifically needs to hear about these criminal cases and the acts. He certainly asked plaintiff about all of these acts in his 3-hour examination. You got into those things. You certainly opened the door. You can now not try to take advantage of a legal loophole that you charged right through with the plaintiff. So counsel, continue. I'll allow it.
So going back to Exhibit I.
Yeah.
And that was a criminal complaint filed on October 6, 2016 regarding a violation of a temporary or extended protective order against domestic violence, correct?
That's what it says.
Okay. And that was for an incident that occurred on August 21st, 2016, in which you arrived, you were within 100 yards of the Canyon Ridge Christian Church, correct?
Now there was an order saying that I was not to go to find another church.
But this complaint
and
is
I was
in
not
regards
at.
to you being within 100 yards of the
I
Canyon
was
Ridge
confused
Church.
under that order. There was a separate entity from Canyon Ridge. There's an actual auditorium, and then there's a daycare which is within over 100 feet. And that was what I was confused about, and I was
But
going.
if we look just at the complaint, it was regarding you being within 100 yards of Canyon Ridge Christian Church, correct?
That's what it says.
Okay. And I'd like to admit this criminal complaint as plaintiff's first trial exhibit, Your Honor.
Any objection?
That this has been adjudicated. Well, it's still on. Well, I don't believe this has relevancy to this case because it shows that it's just a more poisoning of the well to show what happened. I mean, it's up to you, Judge.
Okay. I'm going to allow it. You certainly questioned plaintiff about it for some time, about the event. I think it's appropriate. It'll be admitted.
And based on that complaint, you were sentenced to you received a suspended sentence of 179 days in jail for that charge, correct?
I was thrown in jail for over 5 days and missed out on a business trip to Canada, and I was almost fired from my job because they didn't know where I was at. I wasn't even able to make a phone call.
Okay, I will refer you to Exhibit D. It's a register of actions. Case number C1162845A, and it's been marked as plaintiff's exhibit. It's base stamp PLA 000206. See that document?
Okay. No contact with the victim. I had no contact with the victim.
If you look at the 11th item down that's dated 12/8/2016, does that say sentence, suspended, jail 179 days?
Yes, that does say that.
Okay, and if we look further down,
It also says trouble broad due, so stay out of trouble broad.
and then we look further down towards the bottom of the page, date 1/12/2017, says revoke, and then right under that sentence, jail 179 days, correct?
It does say that, okay. And there was more than 2 days credit time served, but
I would like to admit that as plaintiff's second trial exhibit.
Any objection?
under NRS, that statute that I stated, the 48125, sentence 2, that this was a no low contendere plea. It was Mr. McDonald I did not understand the implications of pleading that. I didn't know I'd lose my appellate rights, and also I did not understand the broad stay out of trouble order, as I've never been in any criminal proceedings or in trouble with the law before. So I would say object to it based on that.
But you concede that you were sentenced to 179 days on January 12th, 2017?
For the phone call, yes, Judge.
All right, and you agree that you pled nolo? Is that correct?
To the phone call?
No, on 12/8 you pled nolo. Is that correct?
I believe so.
You found guilty? Is that correct?
No, Judge, that's not correct.
You were not found guilty?
That was NOLO is it's not pleading guilty to.
No, you were found by the court
Oh,
and
was
adjudicated guilty.
Yes, Judge.
All right. You were ordered to stay out of trouble. Is that correct?
The broad, stay
All right. And 179 days were suspended.
which I did not understand. Yes.
Okay. And you were supposed to stay away at least 100 yards from the victim. Is that correct?
Yes.
I'm not going to admit it based on your objection.
Then back to Exhibit J. And again, have you seen this document?
Yes.
And what do you understand it to be?
Criminal complaint,
Against you, correct?
which yes, I didn't understand. But yeah.
Okay. And if we look on the document, count A is for a violation of a temporary or extended protective order against domestic violence, correct? Mm-hmm. And count B is battery, which constituted domestic violence, correct?
Yes, which battery, anything can constitute domestic violence. It's very vague in our statutes.
And this was filed against you on November 30th, 2016, correct?
That's what it says.
And it was based on an incident that occurred on November 11th, 2016, that we have talked about at length today, correct?
Veterans Day, when the kids didn't have school. Yeah.
And did you go to trial on these charges?
I was unaware of it being a trial, and there was no process of law, and that's on appeal right now. And
Okay. Were you adjudicated guilty of these charges?
I believe I was.
I'd like to admit this criminal complaint as Plaintiff's Exhibit 3, Your Honor.
Any objection?
This should also pertain to that, I believe, as it was already, or maybe
Well, you went to trial on this case, right?
at the time I did not understand it was trial, but yes, Judge.
Or did you have a lawyer?
I had a public defender
Okay.
that didn't present any evidence.
Okay. And you didn't know it was a trial?
No, Judge.
Was there witnesses?
Only her parents were witnesses.
Okay, so there was witnesses.
I asked for due process to have witnesses.
Was
and
there a judge there?
Judge Almasi was there.
Okay, and you had a lawyer.
Public defender, yes.
Do you know that a public defender is a lawyer?
Yes, Judge.
Is there something else that they are? I mean, you say
No.
you keep correcting me when I say.
No, Judge. There was also a bar complaint issued on that particular Julian Gregory.
Okay. But you you did not understand at all that it was a trial?
No, Judge. He did not prepare me for trial. I sent in evidence and things, but there was no violations. I did not know it was a trial.
Okay.
I was also moving my whole building from my old office. We moved to a 25,000 square foot building. I was completely engrossed in that. So at the same time as this going on, I was in charge of buying all the IT equipment, doing all the move and stuff. And
Okay, so I'm a little bit concerned. Do you know what today is?
today is an evidentiary hearing.
Okay, what does that mean?
That you make determinations based on evidence of in this as regards to custody.
Okay, do you have any questions about what today is?
No, Judge.
Are you sure?
I don't want to take up the court's time.
No, I want you. You're on counsel's time, and I'm taking it up. If you didn't understand that that was a criminal trial, I'm worried about your competency to be here today, all right? And if you understand what today is. So that's why I need to know, for my own benefit and for your benefit, whether or not you understand what's going on today. Do you want... Is there anything that I can explain? Is there any question in your mind?
Well, there is one question, Judge. I would ask that there's a concern of jurisdiction of what family court and municipal court had, which I was not present to or know, and maybe Judge, you can clarify, is that there was orders issued into this court. Yet it was there were, and per your order, you said any violations of my orders you receive 25 days in jail. Now, supposedly those orders were violated, yet they were remanded to a criminal matter, and which you can do up to 179 days for, which I attended and happened. So what I ask is what, and there's another thing, that it was also under the jurisdiction of the Supreme Court, especially in regards to the custody when I had the children every weekend or every other weekend and then Hardcastle denied those visitations. So,
Okay, so what is your question?
so the question is jurisdictionally, does the criminal court have jurisdiction over family court orders?
I think what you're asking is it a crime to violate the temporary protective order or extended protective order? Yes, that's a separate crime for which the Las Vegas Justice Court, the Las Vegas Municipal Court, has jurisdiction. Do you have an objection to my jurisdiction today? Is that your question?
Well, Judge, I would ask that do we have jurisdiction over criminal matters here in family court? And especially, and if it was under Supreme Court rule, or it was under pending Supreme Court, did Judge Hardcastle have the authority to, or the jurisdiction?
I can't be your attorney. I can't give you legal advice. I'm concerned because some of these topics are really complicated. And if you didn't know you were sitting through your criminal trial, okay, then I'm worried that you're not going to be able to understand my answer to your question. My answer to your question is not relevant today. If you have an objection to my jurisdiction today, hearing this family case, it's denied. I have jurisdiction. My jurisdiction is continuing over this custody matter. You filed your motion here. You submitted yourself to my jurisdiction. Your children live within the county. You live within the county. You live within the county. We're all here and submitting to my jurisdiction. So I'm proceeding today. I can't answer all of your questions about all of your interactions with other courts. I'm not sure that it's very relevant to what we're doing today.
Okay, that's
But you understand beyond that what we're doing today and what's going on here.
There should be a determination of custody based on evidence presented to.
Okay. All right. Counsel, continue.
And so you admit that you were adjudicated guilty of count 1, violation of a temporary protected order, and count 2, battery constituting domestic violence, with regard to the criminal complaint that's attached as Plaintiff's Exhibit 3, correct?
Which is on appeal currently, yes.
Okay, but you were adjudicated guilty. And you were sentenced to 25 days in jail, correct?
For the domestic violence, supposedly pushing.
And with a suspended sentence of 179 days that was consecutive with the other violation of protective order, correct? Were you ordered to complete domestic violence classes?
Yes, there is an order to complete domestic violence classes, but they're all.
How many were you to complete?
This is a first offense, and I was told to complete 52 domestic violence classes within 3 years.
And so far, you admitted as one of your exhibits that you, while in the Las Vegas Municipal Court, while in jail, you completed 15 classes, correct?
While in jail, yes.
And you have not produced any evidence to show that you've completed any additional classes, correct?
So before I came to this court, I tried to get documentation from SafeNest to show my 10 classes that there was some that did not count as I was a few minutes late to the class.
Okay, but you've produced no signatures, no registry sheets, nothing.
They said I had that the court would already have that, so I believe this court should be able to pull those completed.
You did not produce those, correct?
I produced a SafeNest booklet that shows that I am attending those classes that don't have a registry.
Where on that booklet does it show that you are attending?
If you look on page 6, that is the alternate to domestic violence. That is the book from SafeNest,
Okay.
which I.
But where on that book does it show Michael McDonald was present on this day for this class?
What I was told from SafeNest is that the court had access to that information.
Okay. But you did not produce anything for today's hearing showing that you've attended any additional classes, correct?
They would not provide that to me. And my counsel did not subpoena that. For previous counsel.
Were you also ordered to complete a domestic violence level 2 class?
Not that I recall. An intake? Is that what you're... There was an intake done at SafeNest. The one that was in municipal court was too expensive. I was told by my previous counsel to go to SafeNest and complete it, which I have done. And I've also been...
And again, you haven't produced any evidence to show that you've completed or taken any additional classes, correct?
I was told by SafeNest that you guys would have... the court would have access to that information.
Okay, but you didn't produce anything, correct?
No, I was unable to.
I'll have you turn to what's been marked as Exhibit K, Plaintiff's Exhibit K. Have you ever seen this document before?
I don't recall, possibly.
Okay, and what do you understand this document to be?
I was supposed to get out of jail in May of 29th of 2017, and the plaintiff went and filed more things, journal entries and text messages.
I'm going to ask you to just answer the question. What do you understand this document to be?
This is a criminal complaint on text messages of how I can get presents to my children.
Okay, so this is a criminal complaint filed against you, correct? Yeah. And if we look at the second page, it's bait stamp PLA 000218. Up at the top it says it's dated February 8th, 2017, correct?
Okay.
And this is based on an incident from December 24th, 2016 and January 3rd, 2017, in which you were charged with violation of a protective order for repeatedly and continuously attempting to contact her via text messaging and or phone calls and or attempting to contact said applicant via texting said applicant's parents and attempting efforts to contact her.
I would
That's
ask...
what the complaint says, correct?
Okay. I would ask that this be precluded based on NRS 48-125 as this was a no-low contender, as I didn't want to... I had 179 days suspended over my head, and I took a plea deal just to not be able to not to go back to jail. I had to get bailed out by my parents for $5,000. After that, when I was supposed to get out, they kept me in an additional 10-15 days, and I was bailed out, and then I took a plea deal.
Okay, but this
Hold on. So my same ruling stands. Let me, as I've looking at other cases, also indicate that it talked about Taylor versus Thunder, but Pasadena police officers versus Pasadena 51 Cal 3rd 564. Evidence of a no-low plea is admissible in subsequent civil proceedings consistent with the terms of NRS 48035, which states evidence will not be admissible if its probative value is substantially outweighed by the danger of unfair prejudice. Moreover, 48035, evidence of another act or crime that is so closely related to an act or controversy or crime charge that the ordinary witness cannot describe the act in controversy or crime without referencing the other crime shall not be excluded. Mr. McDonald specifically opened the door to these instances by his questioning of the plaintiff at length. They were not passing questions. He questions her about the specifics of each of these actions. He has brought up to this court and indicated part of his argument has been his time in jail, these criminal cases. He's given us pieces of paper about the silver bullet, and his whole argument, your whole presentation today, revolves around these criminal cases. And so it is absolutely relevant. You've opened the door. I think the case law and the statute support this decision clearly and unequivocally. Counsel, continue.
And so you were charged on February 8th, 2017 with another violation of an extended protective order based on telephone calls and or text messages from December 24th, 2016 to January 3rd and January 3rd, 2017, correct?
I don't recall. That's what hearing was.
Based on this complaint, that is what the complaint says, correct?
This complaint says that it was entered in February 8th, but it didn't get prosecuted until after I got out in around around June of 2017, if I recall right.
So I will move to attach the criminal complaint attached as Exhibit K as plaintiff's fourth trial exhibit.
Counsel, Mr. McDonald, I know that you've stated your objection for the record. That objection will stand.
Can I say one thing?
Sure, go ahead.
So this is that just as for the court to bear weight on it is a text message or phone call attempting to contact the applicant. There was nothing saying in regards to Candace. It was only in regards to his children and getting presents to the children. And that's what weight this count has. And there was no order saying I was not to contact. I believe there was none that said that I couldn't contact her parents at that time.
And you were adjudicated guilty of that charge, though, correct?
By no contest, yeah.
Mr. McDonald, do you feel that you carry any responsibility for what has occurred in this case, with you not being able to see your children?
Yes, in some regards.
What responsibility do you think falls on you?
In regards to what?
To not being able to see your children.
And my responsibility? Well, confusion for one. There were orders that were unfollowable in my eye. I didn't understand. They were contradictory. Me and plaintiff tried to follow the order as best that we could. We didn't understand it. We tried to get clarification, and I didn't have counsel, and asked Judge Hardcastle to clarify the orders. I was shut down, wasn't able to speak, and they were not addressed, to my knowledge.
And do you recall Judge Hardcastle ordering you to get a psychological evaluation back in November of 2017?
I don't recall. It was so I was devastated by getting orders where I can't see my kids or property. So I don't remember too much of that.
Okay, but isn't it true that you have not received a psychological evaluation since November of 2017?
Since November of 2017. No, there was two previous evals. So
since November of 2017, when Judge Hardcastle ordered you to get a psychological evaluation,
there was
you
one.
have not.
No, 16. That's when she injured that. So you're correct. November of 2016. Yes, there was an eval.
In November of 2016, there was.
No, you said that was ordered.
So after November of 2016.
Yes, there was one after that.
Okay, have you provided any proof of that?
It's on record with the court.
But you didn't produce anything.
My previous counsel did not subpoena those records.
And is it your belief that you have followed every order of this court?
I've done my best to follow all orders of this court and the municipal court, as I don't want to go back to jail or
Do you believe that you would have been sentenced to serve time in jail if you had been complying with all the orders?
I believe I did my best in my ability to follow the orders, and it wasn't an unwill. In our statute, it states that there is a blatant and willingness to violate those laws. I was not willing to violate those laws, and as you can see with the text
Did
messages.
somebody force you to violate the orders?
In my opinion, yes. Yes, as counsel, as plaintiff said, come pick up the children, or you're going to lose your weekend, or I'll pick them up. So that's when, yeah, I tried to make a judgment call.
Assuming that that's the way it
She
really
said she
went
was
down,
there, so I wouldn't.
Assuming that's the way it really went down, couldn't you have just said that's a violation of the order? I'm not going to.
I did. If you look at the text messages on exhibits, what is it, 42? It says please follow the court orders, and it wasn't a willful and unlawful violation of this court's order. So if you look at that, I was put in a predicament where how do I?
But by court order, you were supposed to pick the kids up at 9 o'clock in the morning, right?
That I don't recall. I believe that it said that on those days. It did not say a time, if I recall correctly. I mean, we can look at the divorce decree and check.
So it would have just been kind of random. You just show up whenever.
That's why talking parents, we were supposed to be good co-parents and come up with a time if things come up. And that's what I believe the judge allowed. So yeah, if you want to look at those text messages, we could bring those up again. Where is it?
But you understand that when a court advises you that you are to have no contact with another party, that means no contact, correct?
So there was confusion on the no contact, as we had talking parents.
If the court tells you that you are to have no contact,
And
do you understand that to mean that there should be some contact or no contact?
No, I did not want any contact with my ex whatsoever. Only in talking to regards to our children through talking parents, which I was doing my best to follow. As we can see, the text messages on page.
Do you believe that you've ever had inappropriate conversations with your kids regarding this divorce case?
Did I ever inappropriate conversations? No, there was never inappropriate conversations. That's complete hearsay. I took the COPE class. I know what to say to my children.
Did you write them letters from jail?
There was letters that were
Okay,
written.
what'd you say in the letters from jail to your kids? You wrote letters to your kids, correct?
Judge,
Hold on, no, one at a time. Did you write, when you were in jail in spring of 2017, did you write your children letters?
Possibly, yeah.
You don't remember?
Yes, Judge.
You did? Okay, how many letters did you write each of
I
them?
don't recall.
Was it more than one?
Possibly.
Okay, so in letters to Mason, did you say anything bad about their mom?
I don't recall, Judge, ever saying that. It was very emotional to be in jail and not see my children for over 6 months.
I understand. So tell me what you said in those letters.
Well, I drew them pictures. There was some
Okay.
letters that
What'd you write in the letters?
the pictures were.
No, what'd you write in the letters?
I don't recall all the things. I remember saying I love them, I miss them, and how I look forward to being their coach and being able to see them, and all that. I think about them and pray about them each night. I wrote all those things. I love them. Daddy hasn't forgotten about them or abandoned them. I put those things in, and I also put some of that in regards to if when they get older, maybe they ever want. I don't know. Wasn't sure if they were ever going to get to my kids, but
Could Mason read?
Mason can read, Judge.
No, in 2017 when you were in custody, Mason was able to read?
Judge, Mason can read. I spent.
No, my question was, in 2017 when you were in custody, could Mason read?
Yes, Judge.
Okay,
I
can
read them every night.
no, not whether you read or
Sorry.
Can he read?
Yes, Judge. You can read.
Can Malia read?
No, she can't read.
Okay, so why were you writing her a letter?
It was mostly to my son, Judge, but
Okay, but why did you write Malia a letter in 2017 when you were in jail if she couldn't read? What was the point of that?
I think I addressed both children. It wasn't.
Well, just help me understand. Just, I want to understand why you did that.
To what? To write?
Why you wrote them letters while you were in
So
jail.
how would you not want to?
No, not a
I wanted
question.
to communicate with my children, talk to them as I had them every weekend for a year, and then almost every other weekend, and then nothing for 6 months being in jail. I wonder what they were thinking about. Did I vanish? Did I die? I had questions, so I wanted to send them.
You had questions, so you sent them a letter?
No, I wanted them to know what was going on. To
You
know.
wanted them to know what was going on?
No, not what's going on. Where their father was. Why isn't Daddy here?
You wanted to tell them that you were in jail? Did you say in the letters, Daddy's in jail because Mommy put him there?
I don't recall, Judge.
You don't recall? Is it likely you said something like that?
It was very emotional. I don't know what was written.
You don't know? You don't know if you wrote that or not?
These letters, I was going to keep them and give them to them one day or something if they ever asked, and this picture, I just sent pictures to them at first. Those pictures are never brought up. I drew things for them.
Not worried about the pictures. I'm worried about you writing these two little kids who can't read. Okay. All right. Let's assume Mason is a great reader for his age, and he can read your multiple pages of why Daddy's in jail. Tell me why you want to tell him at that age that you're in jail and the reason why. I'm trying to get to your relationship with your son and your daughter, and I need more information about that.
I have a very good relationship with my children, and they would ask questions and things. I would do age-appropriate questions or answers. When a child goes and asks you a specific question, as a parent, you
when you're in jail, were your kids asking you questions?
Judge, this is before.
That's why I don't understand why we would write them letters.
Judge, it was an emotional time. Things that. When the children are of age, one day maybe they'll know what happened or what. I didn't know.
Also, continue.
So, I'll have you look at exhibit that's been marked as plaintiff's exhibit E. Is this one of the letters that you wrote to Mason and Malia?
Defendant's exhibit E.
Plaintiff's exhibit E. It's been date stamp PLA 000208.
So what about it?
Is this one of the letters that you wrote to Mason and Malia while you were in jail?
I believe so.
You believe so, or it is?
The words are written. It's.
Would you like to review this for a minute?
Sure, I'll take a minute to. I've not seen these.
You've not seen these?
No, I don't believe that you supplied those to me.
I did.
Did you? An email? This person has pretty bad handwriting.
This person does. Do you know anybody else that would write to Dearest Mason and Malia and title it Dad has been in jail for almost 75 days?
Did you write this, Mr. McDonald?
I believe so, Judge.
All right, next question.
Okay. I'd like you to review that real quick, and then I'll ask you some questions about it.
Is this just for both of these? Okay.
Just this first page.
Okay.
Okay, you see any reference in there where you allege that you were ordered to pay your mom's attorney almost $30,000?
At that time, I didn't understand that, but yeah.
Then you mentioned it could have been used to send you guys to college. I wish she would have just agreed to all when we sat down with our stepdads. Later on, you mentioned I have lost everything in this divorce, and your mom putting me in jail. Good job, house. And safe with your guys' savings. A lot more. I have nothing, and I'm going to have to start my life over again, and I'm homeless. Do you see that?
Okay.
You think that is appropriate stuff that you should be addressing with your children?
So, did the children ever see this?
That's not my question.
Well, you know what? If you're thrown in jail and
Okay, the question is, do you believe that that is appropriate discussion for a 5-year-old and a 2-year-old?
well, was he 6 at the time? No, I would not bring these. Some of these discussions would not be appropriate for.
You don't believe that's appropriate. But you wrote this out and sent it to them, correct? Correct?
I don't recall, and I don't believe they've ever seen this. So yeah.
You don't recall sending this to them?
I don't recall seeing it or sending this to them.
So you've never seen this before?
I believe, like I said, I don't recall seeing this.
But didn't you already admitted that you wrote this?
Did I admit that? This could be altered or things, but no, there's. I don't recall my kids ever seeing this. There was an emotional time being in jail, but I wouldn't have inappropriate conversation with my kids.
Okay, I will move to admit this page, plaintiff's exhibit based on PLA 000280.
Any objection,
I'd
Mr.
like to
McDonald?
object to that as for the validity of this. It wasn't signed. There's no date on it.
You just told me that you wrote it.
I didn't say I wrote it, Judge.
You didn't say you wrote this 5 minutes ago? What did you tell me?
This it looks like some of my writing and things, but this could have been altered. There's no signature. There's no. I'd say based on just being a scribble on a piece of paper, you wouldn't be able to admit this. This is not original. I didn't write this copy here. This is not what I wrote. Do you like?
No, I understand. I think what your objection is that you didn't.
Validity or objection.
I get what you're saying.
There's no signature. There's no date on it.
You didn't tell me that you wrote this 5 minutes ago?
I don't recall if I said that, Judge. Did I? So just based on that, that's the I don't know the rules of evidence, but I think it says it has to be validated and stuff like that. And it hasn't.
Counsel, I'm not going to admit it.
Your Honor, he clearly admitted to writing the
I heard him.
letter.
But I'm a little bit concerned about something else. So we are going to take a 5-minute break, and then we are going to come back.
We're at recess.